Good morning. If I can get your attention for just a few minutes. Thank you for coming today to hear Judge Gajarsa. I'm interested in listening to his lecture. In his usual humble fashion, he tells me it might not be that exciting. If you haven't met Judge Gajarsa, you should take the opportunity. He's currently mentoring a half a dozen students on writing skills. He's been working with some of the students on advocacy, including the moot court team that just finished so highly in the trademark competition. Judge Gajarsa was in private practice for many years. In 1997, he was nominated by then President Bill Clinton to go on the Court of Appeals for the Federal Circuit. This past year, he took senior status. And in response to my request, but not because I asked it, but because of this school, and the incidental fact that Judge Gajarsa has a house on Squam Lake, which didn't hurt, I must say, he agreed to be the first distinguished jurist in residence at this law school. He's enormously well qualified to talk on this topic today, and I hope, and I think I can speak for him in saying this, that you take advantage of his time here as the first distinguished jurist in residence in this law school. And in the world of IP, I can't imagine getting someone better. So please take that opportunity. Judge Gajarsa this spring will be granted an honorary degree by Georgetown Law School, where he taught for many years. And so we could not be more thrilled to have him here. And so with that, I'd like him to come forward. I do want to acknowledge one special guest at the risk of embarrassing him, which I'm sure I will. But Judge Barbaduro from the U.S. District Court has discreetly taken a position near the back of the room. And so it's a great honor to have him at the law school as well. So with that, Judge Gajarsa.
Thank you, Dean. Good afternoon. I should say good morning. I'm glad to see that they decided to serve lunch. Otherwise, we'd probably have 5 people in attendance. Free lunch is always good to have. And it's such a nice day that when I was at Georgetown, the classroom I was assigned to in the springtime had a terrace. So I would suggest to my students that instead of having the classroom in the classroom, which was rather dingy and old and not decrepit, but old, we'd go out in the terrace and have the class out there. I was going to suggest we have the class out in the park today, but I was vetoed on that point. Otherwise, we'd all be in trouble. I wouldn't be able to lecture and you wouldn't be able to listen. AIA, big numbers. Short for the American Invents Act, Leigh-Smith Act. Call it whatever you want. It has 37 sections, 58 single-spaced pages. Can you imagine a statute? Not like the health care bill, which had 2,800, and I dare anyone to say what's in it with any knowledge. Same way with the AIA. Let's not forget that in 1789, when we had a Constitution, patents and copyrights were identified in the Constitution itself. That Congress could pass laws protecting inventors and artists. The first patent was issued by a committee consisting of 3 members of the cabinet. Can you imagine that? 3 members of the cabinet sitting as a committee to pass on patentability? One of whom was Thomas Jefferson. Second one was Hamilton. And the third one, because nobody else wanted the job, was Frank Knox, who was the Secretary of War. From 1789 forward, then they allowed others to pass on patentability. In 1837, there was a new Patent Act. When Edison, Thomas Edison, and even Morse filed for their patents, it took them 2 months, 3 months to get those patents out. Think about that. New technology that no one really had thought about. Telephony, Morse code. 3 months to get a patent. In 1870, the new act was also adopted. We still had general statutes. In 1952, 2 individuals were charged by the Congress, and they took it upon themselves to codify what became known as Title 35. One of those 2 individuals was Giles Rich, who became a judge on the court of CCPA at first, and eventually in the court of the Federal Circuit. Judge Rich was probably one of the most knowledgeable individuals of the 1952 Act. Second individual is a fellow who was a primary examiner at the Patent Office. His name was Pasquale Federico. I had the privilege of knowing both gentlemen. Pat, because he eventually left the PTO and became of counsel to a firm that I worked with, Cushman, Darby, and Cushman. Judge Rich was still an active judge when I was appointed to the Court of the Federal Circuit. He passed away in 1999 at the young age of 95. And he was marvelous, because both of those individuals knew what they had to do to essentially put together a Patent Act which for the first time recognized obviousness as an item of patentability. If it was not obvious, then you could obtain a patent. Judge Rich was the one who coined that, although it had been in the general statutes before, but it had never really been recognized as an item of patentability. 2 individuals wrote that act. It lasted for 60 years. It had a lot of nuances, a lot of interpretations. In 1982, there was also another watershed change to the patent law, due primarily to the fact that a number of patent holders complained about their inability to protect their patents. If you selected the circuit correctly, the Circuit Court of Appeals, you could get your patent enforced. If you, by chance, ended up in the wrong one, you had a serious problem in protecting your patent rights. The Eighth Circuit was rather infamous for that. From 1917 to 1982, the Eighth Circuit Court of Appeals did not find one patent valid and infringed. Think about that. Think what it did to the patent system if you were unfortunate enough to have venue in the Eighth Circuit. The Second Circuit was a little bit better. The Seventh was good. The Ninth, as usual, was the largest of the circuits, and it was so-so, depended on the panel. There was a fellow by the name of John Mayer who was a professor of law at the University of Virginia. And he was totally blind. And he had this concept that we should have a Court of Appeals stationed in Washington for the specific purpose of having cases appealed from all over the country to unify the patent law around the country in one appellate court. Still have your trials at the various district court levels, but have one circuit court to hear the appeals. John was very forceful. He started working on the legislation during the Carter administration when he was in Washington. He was an assistant AG. And eventually convinced the Congress to pass the statute. At that time, they essentially merged two Article III courts. The CCPA, which consisted of 5 judges. The chief judge was Markey. And the Court of Federal Claims, which was also an Article III court, 7 judges, and the chief judge was Danny Friedman. They did the numbers, and they came up with 12. They added up 5 and 12, 5 and 7, and came up with 12. So it's an even dozen on the Federal Circuit. President Reagan signed the law, and for a while, the Federal Circuit could do no wrong. We had a very strong honeymoon period with the Supreme Court. They took very few of our cases in review. They allowed the Federal Circuit to set the standards. It's always been my contention that the mandate which created the Federal Circuit gave the Federal Circuit the parameters of trying to nationalize and harmonize patent law throughout the country. So that if you tried a case in the Northern District of California, or you tried a case in the city of Boston, the same patent law interpretation would apply. That was the intent of establishing the Federal Circuit, to harmonize patent law. Did it? Tried. For 25 years, we were doing very well. And then the Supreme Court decided, hey, baby, this is pretty nice law. It's a nice area of the law. It has major impacts on the economy. We got to take a look at it. I don't know if you're familiar with Festo. Festo was a case dealing with the doctrine of equivalence. There was a series of 3 cases that came up when I first came to the court. And being from private practice, I always had a problem trying to advise a client on the issue of doctrine of equivalence. How do you tell someone that you're infringing pursuant to the doctrine of equivalence? How do you tell them they're not infringing under the doctrine of equivalence? You take the position that you can't. Maybe yes, maybe no. And if you have a client who at that time would be paying you $20,000, $25,000 for validity and infringement analysis, he would or she would come up to you and say, "You're taking my money under false pretenses. You're saying maybe. And I kept saying, I'm not going to put my errors and omissions policy on the line to give you a yes or a no definite answer. So I get up to the court, and the first three series of cases were dealing with DOE. Supreme Court had just decided Hilton Davis, and Hilton Davis was the precursor of several others on DOE. Opinion written by Justice Thomas. I think the youngest justice on the Supreme Court usually gets stuck with the patent cases early on, unless they become watershed determinant cases. So Justice Thomas got stuck with the case, and he wrote an opinion saying, if in fact the determination of the amendment to the patent claims is not known, there's no reason that's determinative on the record, then you can't get the doctrine of equivalence to cover the particular infringement, which makes sense. If you don't know it, you presume that it's for patentability, and you eliminate it. It's not infringed. 3 cases were sent back to the Federal Circuit. First one was Hughes versus the United States. Second one was Raytheon versus Honeywell. All 3 dealing with the particular doctrine of equivalence. First one we requested an en banc, got 1 vote, and that was Honeywell versus Raytheon. On Hughes versus the U.S., we got 3 votes for en banc. It takes 4. So we were chipping away. 4th one came back, and it was Festo. Festo we got up en banc. 8-4. The rationale of the Federal Circuit is pretty straightforward. Taking its lead from the Supreme Court on the Hilton Davis case, in Festo, the reason for the amendment was well known. What happens? We said, if you know the reason is for patentability, no DOE. Pretty clear cut. And lo and behold, the Supreme Court needs work. You realize they only take about 75 cases a year on cert. Now, if you do the math, and you're all pretty good at math and science, 75 or 78 divided by 9, that's around 9 opinions per justice. Not too bad. That's 3 square meals, no heavy lifting. Even if you write some dissents. And they sit from the first Monday in October till the end of April when they have hearings. And then they sit for 2 months writing their opinions, because they do have a rule that all of their opinions have to be out by June, the end of June at least. And they're all anxious to leave the country at the end of June. But they came out with an opinion on Festo saying, you're wrong, Federal Circuit. And there was a statement made by one of the justices during a conference that they were beginning to recognize at the Supreme Court level the value of patents. And in 2004, during that term, the justice made the statement that Festo was the most important business case before the court at that time. And that really started the review by the Supreme Court of many of our cases. I made the statement one time that after 10 cases had gone up and 10 cases had been reversed, that we were becoming the Ninth Circuit of the 21st century. And my colleagues took umbrage at that. However, this all leads really to the new amendment, which the President signed into law in September 16, 2011. I said it's a long statute. We're going to have fun with it because all you will be getting today is a cursory review of the highlights. We'll have more lectures. So I'm going to entice you into coming back 2, 3, maybe 4 times to get the full load of what's in that bill. You begin to wonder whether, when the bill was signed, Senator Leahy from our neighbor state of Vermont made the statement that this was a full employment bill. And Senator Leahy is a Georgetown Law School graduate, and I know him reasonably well. And after that statement was made, the next time that I saw him, I said, full employment for whom? Not for scientists, not for engineers, but for lawyers, Pat. You're going to keep lawyers busy for the next 20 years trying to decipher what's in that bill. It's going to take our court maybe even longer, because many of the cases that would entail an interpretation of the act will take 2, 3, 4 years before they arrive up and they're ready for appeal. The Patent Office right now is issuing proposed regulations. They started in January. Now, the other aspect that I think people will start litigation is a determination of whether the regulations which the Patent Office adopts and proposes, even when they become final, does the Patent Office have substantive rulemaking regulation as an agency? If you've taken administrative law, you know that the Patent Office cannot make substantive rules on the law. They can't take 102 and 103 and issue a regulation as to what obviousness is under the law, can they? Because they do not have substantive rulemaking regulation like many of the other agencies do. The independent agencies, the SEC, the ICC, the old ICC, the FCC, all of those agencies have substantive rulemaking capacity. Even under Zerko, which was an issue that came up to the Supreme Court, the Supreme Court recognized that the Patent Office could adopt procedural rulemaking, but it had no substantive authority to make rules on legal issues. They're making rules right now. I think at this point in time, they probably have between 50 to 75 rules interpreting the act. I think one of the first cases that's going to come about is whether or not the Patent Office has the authority to do that, even though the act itself gives them the authority to implement regulations. Are those regulations regulatory, procedural, or substantive? It's a very fine line. It's going to keep the courts busy for a long time. Now, one of the other aspects that the law does change is the venue. When you're challenging the Patent Office, you challenge a Patent Office in the past before the district court in D.C. Now it's the Eastern District of Virginia. Now, the Eastern District of Virginia extends from Norfolk up through Richmond and Alexandria. Is Alexandria the only venue which is available in the Eastern District to sue the Patent Office and challenging these regulations? And I'm sure there'll be challenges to the regulations. There'll be facial challenges and eventually substantive challenges as applied. A lot of work for lawyers. I'm glad you're graduating soon because you'll have full employment. And the aspects of understanding what the act does, for instance, just to give you some flavor for it, it changes the substantive aspect of inventorship. It follows the rest of the world from first to invent, first to file. And the transition basically is going to take a while. It's a 1-year grace period before it becomes applicable. Then there's also another 6 months, so 18-month grace period. And it also requires people to proceed on the basis of filing and then worrying about others following behind. What used to be called interferences, because the United States was one of the only countries in the world that identified a patent by the inventor. If you were the inventor, you reduced it to practice, you had conceptual and reduction of practice, you were the inventor. If you could prove that, even though you may have filed a patent application second to someone else, you were the inventor, and you were entitled to the patent. That's not the way it was with the rest of the world. The rest of the world followed a first to file. If you were the first to file, but were not the inventor, you would still be entitled to the patent. So instead of an interference practice, there's Section 3, which is probably going to take a whole lecture to go through and analyze not only the pros and cons of it, but the changes that the law makes. Instead of calling it interference, we now have a derivative practice. Think about that. Almost like calculus, derivative. We've gone back to math instead of interference. But it's a new concept where if an inventor derived the idea from someone, then the question is whether or not the invention was derived from the first party by the second party. So you have a derivative practice instead of interference. Is that a full first to file concept? I wonder. Just think about that. The second problem that I have with the first to file is that you're going to have patents which are issued under the old system, which will be valid for a long period of time, probably 20 years. What happens after that? It means that we're going to have a two-tier system. We're going to have the old law to litigate for the old patents, and we'll have the new law to litigate. Think about it. Does that make sense? It does if you're going to go through a transition. It does if you're going to change the concepts of first to file. I wonder if that is the best solution to the problem. There was a lot of objections, by the way, to the first to file. By whom? Guess. You're sitting in one place where the objectors would be the most. University level research groups vehemently objected to first to file. Most of the universities did not like it. Why? Because it places an incentive on individuals who are quick on their feet and can react to the notebooks and getting them filed and getting them prepared. I'm sure you're aware that in many universities, when you do research, you have to get approval before you file a patent application. That's a bureaucratic structure. And you might get the approval, you might not. And it takes time. The first to file rewards the people who are quick. They're the ones who essentially win the race to the patent office. And other sections, which we need to cover really in depth, and this is just a cursory analysis of what we have. So the first inventors to file is under Section 3. Section 4 is just the inventor's oath and declaration. You can now have the assignee sign the oath, and they've also removed the requirement for the statement of lack of deceptive intent. Then there's also a change, basically, on defense to infringement based on prior commercial use. There's a Section 278, which provided for prior commercial use to be a defense, and we could spend 2 hours just explaining that one as to what is prior commercial use today and what it is under the new law. These are just points that you need to focus on. And I suspect that the school will be offering a course on the law itself, explaining it section by section, because you need time to digest it, to consider what the alternatives are, and to actually interpret the language as the Patent Office is trying to do right now with the regulations. Those regulations are subject to comment, and they probably will not be finalized before the end of the summer, the beginning of fall of this year, if even at that point. Because once they are finalized, then the fun begins. That's when lawyers start challenging the facial aspects of the regulations. The second major change which the Act made was a post-grant review proceeding. They amended and included a new chapter, Chapter 31 of Title 35, and it replaces the optional inter partes re-examination. So you have post-issuance examination of patents by the patentee to provide for prior art or information which was not submitted during examination. And this was done basically to eliminate some of the problems of litigation when some people's patents were challenged on the issue of being invalid because of inequitable conduct before the patent office. So now if you find a piece of prior art after the patent is issued, you can ask the patent office to re-examine the patent. But you have to do that within a certain period of time. It's 9 months. It changes the whole scope of patent prosecution and patent analysis. These are all items that you're going to have to take into account whenever you practice patent law. It's intellectual property at its finest, and I think, as I said, it's going to be full employment for lawyers for many, many years to come. The other aspect which that brings in is an inter-party analysis where people can challenge a patent validity and bring in new art to challenge particular claims or all of the claims. The question is the patent office going to be inundated with these particular actions after issuance? The statute provides for the director to have a limit on the number of these cases that will be coming about during the first 4 years. He is hiring now new administrative law judges. I think Mr. Kapos has brought in at least 100, so he's up to 200 administrative law judges. Because each one of these procedures requires a panel of three administrative law judges. You can also ask for an oral hearing before the administrative law judges if you're willing to pay the fee. It's a $4,800 fee. Excuse me. Some of the fees that have been added to the patent prosecution and patent process before the patent office are, I think, enormous for small inventors, even though there is an exception for micro inventors or small inventors, and for small businesses, they're still pretty stiff. When I first started prosecuting patents, the patent application was $30 for 10 independent claims and 10 dependent claims, so it was pretty cheap. Now it's about $4,800 to get through the process alone. They are making money, but they're not keeping all of the money available for the operation of the patent office. This is a big issue that Mr. Kapos has. But just think about that. If, in fact, under Section 6 of the new Act, which is the area for post-review and post-issuance, you have, for the moment, 200 administrative law judges. His aim is to bring in 400 eventually, because this post-review area is going to be the active area, I believe, of the new law. So even if you have 400, you have 100 some odd panels actively all the time. And if they hear appeals, direct appeals and indirect appeals from third parties who can participate, and if they lose, then they have the right to appeal to the Court of Appeals. I am figuring that the number of cases that will be coming up to the court will rise from Right now, it's about 1,500 cases altogether, 1,600 appeals. We'll probably double in the first 5 years and triple in the next 10. Just because of these post-issuance proceedings. Pretty active area of the law. Now, if in fact we look at the rest of the aspects of what we're talking about, those are the two areas which are going to be most active. The venue changes that have been made, as I spoke about before, venue was made to the Eastern District rather than the D.C. District Court. You also have another change of venue, which essentially was a major one. The Toronto case, when it came out, allowed for patent appeals to be taken to regional circuits or to state courts. Because if the patent was alleged as a counterclaim, it was determined not to arise under the patent laws if it was a counterclaim. So we had several cases that were taken to the regional circuits, and the regional circuits, being very, very smart folks, decided to follow federal circuit law. They didn't want to really delve into areas that they had very few cases in, so they followed federal circuit law. Same way with state courts. There was a state court in Indiana that had a case that arose under a counterclaim for patent infringement, and they followed the law of the federal circuit. Now the law has been changed under the AIA, making that particular aspect, if it's a counterclaim, which is compulsory under the law, it goes to the federal circuit on appeal. So that's been corrected. However, we also have some discussions of strategies deemed to be within the prior act tax strategies. If you recall, we've had a number of business patents which dealt with tax strategies. Those are no longer patentable, even though Bilski never reached those issues. The best mode requirement as a defense has been eliminated, but it's still required to be established under 112. You still need to establish a best mode to practice your invention. If you don't disclose the best mode, as it turns out during litigation, it is not a basis for invalidating the patent. The markings area has been corrected, thankfully, because that was a mistake that the Federal Circuit had made in the quitem actions. That's now been corrected and brought, I think, into the proper realm. There's also one factor that you have to consider when you're reading the AIA, that fraud in the patent office is now specific. If the director determines that fraud has been committed on the patent office, he can recommend criminal prosecution by the Attorney General for committing fraud before the patent office. Does that also invalidate the patent? We'll have to find out. But it's a beginning of an understanding that maybe even patents need to have some criminal protection, like copyrights. So a step, I think, which could open up an entire Pandora's box. Not sure. But we could go through each one of the sections and see where the changes have been made. They have changed it. Now, the real question that I have, basic underlying question, patents are supposed to be useful for innovation. Innovation is derived from a strong educational process, strong structure in education. That's how we derive innovation. Creativity, we develop it. If we have innovation, we also create jobs. I wonder if the procedural hindrances and the roadblocks which have been placed in obtaining patents will eliminate the Thomas Edisons, the Morses, F.B. Morse and others, who were individual inventors, where the concepts of innovation come about. Will they be able to protect themselves with patents? Will patents be a valuable tool for innovation under this new act? That's a question that we really can't answer until we see the full implementation of the act itself. Because if it hinders the ability of people to obtain patents for their invention, because if it hinders people from developing new thoughts and new ideas which can be protected, then I think we've lost the game. Because we've always been a country of innovation. That's been our strength. We've exported innovation, technology. Even today, we're still exporting technology. However, if we don't protect our innovation and our ability to innovate, we will become a second-rate country. And we will give up the cutting-edge tools that we've had for the past 225, 250 years, if not longer. That's what I'm concerned about. Now, that's just a cursory analysis. It's going to take a few more hours to get into detail. I think the next lecture, if you're willing to attend, it's going to cost you another nickel to attend. We'll probably be covering Section 3, which is the first to file. And the second lecture after that, we'll need to cover the post-examination, which we'll have to do in depth, and that's going to take a long time because there are a lot of nuances that come about in that particular area of the Act. And those are the two areas I think that we need to develop and need to understand thoroughly. Thank you very much. Questions? No questions?
Just one thing, reading the act that I was curious about is, do you have any insight in particular as to why they said that tax strategies would be considered part of the prior art rather than just saying they're not patentable?
Well, because mostly, if you see the way legislation is made, it's almost like sausage. You don't want to see it made. The big aspect of that particular section, I think, was they didn't know what other systems might be available. So anything dealing with tax is considered prior art and not patentable. Because if they had said that a tax program is not patentable under 101, is it limited to tax at that point, or can a system be patentable if it's not related to tax? I think they took the negative aspect of it rather than the positive aspect. And it was a compromise of language. just like every piece of legislation that you'll ever see is a compromise of language. That's what it's all about.
With the change in the system from a first to invent to first to file, are we changing, this may be something you're going to go over in the next lecture, but are we changing to a true first to file, or are we changing to a sort of hybrid first inventor to file? Because my understanding was that you still had to show inventorship. You just didn't necessarily have to be the first inventor of it. You just had to show you invented it, whatever it is you're attempting to patent. And then if you were the first to file, you could receive a patent for that.
Well, that's where the derivative aspects also come in, too. You're right. It's the first inventor to file, but who is the first inventor?
That's the question.
That's the question that comes up. That's why I think it's a section that needs to be analyzed in depth, because the nuances in it are very, very broad, in the sense that what you're doing is bringing in new concepts, and we can't take concepts from the rest of the world because of our past history. This is why I think derivative analysis was maintained, because people did not want to completely throw out interferences. And interferences did get thrown out with the wash in the process, but they kept a residual portion of it, calling it derivative.
Yeah, so as you speak about this, I detect that not only are there issues in your mind about how this law is going to be interpreted, but also maybe some concerns about whether this is actually the right thing for the nation to do. First of all, is that accurate? And then second, if you could comment on whether that feeling is kind of widespread at the Federal Circuit, or if there's some people that strongly think this is a great thing.
Well, I think from my personal standpoint, there's a lot of aspects of the law that are going to be required to be corrected technically. There's a lot of technical issues that need to be corrected. We're going to end up in a situation just like tax law. Whenever you get a new tax law, you always get a technical amendment correction within the next 12 months. And I think this is what's going to happen here. There's a technical correction amendment going on right now. I think that the hindrances that they've set up, especially the fee structures, in some cases challenging, if I calculated it correctly, challenging a post-issuance patent will cost the petitioner $27,000 before he's out of the box. That's just a filing fee. So I suspect that that's going to limit a number of challenges in that particular mode. And the question that comes up is whether or not, if you don't file in a post-grant situation, are you stopped from challenging in court? And I don't think you are, and I don't think you should be, but there's a real residual aspect to that needs to be analyzed. I think that the bill itself probably brings some good changes to it, provided it doesn't hinder innovation. If we lose innovation because of the obstacles and the particular bureaucratic obstacles that we place on our inventors, then we have a serious problem. And I don't know how this is going to play out. Tell you the truth, I think they went to the board a little bit too quickly without understanding what the full implementation of the bill would look like. They wanted to get a bill. They wanted to get an amendment patent law. And there were two sides, the high-tech community and also the big pharma. And they were at opposite ends of the table. And they eventually reached the compromise. If you notice, the bill itself was passed by the House back in July. and it went to the Senate and was passed without amendment, because they were told that if there were any amendments to it, it wouldn't pass, going back to the House with an amendment from the Senate. So they wanted to get it out. And I think it's going to take some time to correct it. They've put some limitations on it, just like the 4-year limitation on the number of cases that can be brought as post-grant reviews, and the determination there is made by the director. What this time is David Kapos, but he's not going to be there forever. So the next director might decide the limitation is in place, we're not going to fool around with it, and let's implement it directly. David has indicated, Mr. Kapos has indicated that you have to take a look at that so that it doesn't interfere with the process. So he may allow more cases than someone else would. Questions?
Are there specific criteria by which the director will cap the cases or not allow them to go to post-grant?
Those are the ones that are going to be subject to regulatory discussion, because there's nothing in the bill itself as to what the limits are.
What role would you see the IP Center of the law school take in fleshing out the next part of the patent law?
I think you have to deal with the aspects of what we have in the old law, compare it, and because people still remember the old law. It's going to be around a number of cases, and start dealing with the new law and start understanding it as soon as the regulations are in place.
Should we in any way participate in establishing this?
I think you can. You can make comment on the regulations as they're published. You're part of the public. You can send comments in directly, and I would not hesitate to do that, because there's a lot of talent in this center on this particular issue that should be heard. And I think maybe one of the individuals that we'll need to bring up here is a young lady by the name of Janet Gongolo, who is the director of the regulatory review group for the entire patent office. She's a former law clerk at the Federal Circuit, and she's been assigned with writing all of the regulations and taking all of the comments and publishing the final regulations. I think she'd be a very much of an asset to come up here and lecture to the school. But it's in motion. It's moving. Many of the regulations have already been drafted up. They started publishing in January. The law was signed on September 16th, so they had 4 months, but they also had the time period from July, when they first started working on it, when the House adopted the bill in July, to the final adoption and signature by the President on September 16th. So the train is moving. If it's moving in the right direction, I think it can be tweaked considerably before it gets to the next station. Any other questions? Come on, you can take a shot at a circuit judge. Well, thank you very much. We have another lecture sometime in the near future.
I think they won't be quite as shy then.